Article 38, paragraph 1 of the Statute of the ICJ declares the court's function to decide disputes in accordance with international law. Also details the sources of international law as international conventions establishing rules expressly recognized by the contesting states and international custom, and it also states the subject to the provisions of Article 59, judicial decisions and the teachings of the most highly qualified publicists of the various nations. The court has recognized a number of other sources, some are universally recognized. Other sources of international law include unilateral acts of international law by states and the decisions of certain international organizations. An important source of obligation in international human rights law is soft law. The term soft law is a misnomer, as law is hard but it is also flexible. It does encompass treaties which are formal law but which contain loose obligations or voluntary resolutions. The next source of international law are treaties. The law that regulates treaties is neatly encapsulated in the 1969 Vienna Convention on the Law of Treaties. In many senses, this law highlights some of the issues concerning sources of international law and their relationship. The Vienna Convention is binding upon those who are party to it as a treaty and upon others as customary international law. The principal human rights treaties for our purposes are the International Covenant on Civil and Political Rights 1966, the International Covenant on Economic, Social and Cultural Rights 1966, the Convention on the Elimination of All Forms of Discrimination Against Women 1979, the Convention Against Torture, Cruel, Inhuman or Degrading Treatment or Punishment 1984, the UN Convention on the Rights of the Child 1989 and the Hague and Geneva Conventions. A treaty is defined in the Vienna Convention on the Law of Treaties 1969 as an international agreement concluded between states in written form and governed by international law. The Vienna Convention is regarded as reflecting customary international law, and the definition of a treaty is accepted as referring to those agreements which are in written form between states and governed by international law. Treaties can either be between two parties or states, bipartite or bilateral, or between number of states or parties, multipartite or multilateral. The relationship between treaties and customary law should be considered, as they have a very clear relationship between them, but the same obligation can extend to the same state from either source. Thus, the source of a treaty can be a treaty or a custom or sometimes both. There is a complex relationship between treaties and customary law. The two sources tend to, in practice, overlap. If not, they may leave an intermediate area between them. The habit of drafting and debating the provisions of a treaty often leads to clarify as to what is the content of the customary rule. Treaty law will usually supersede the previous contrary customary international law. It can be said that in an event of inconsistency, whichever is the most recent, be it custom or treaty, prevails between the parties. However, more specialized rules tend to prevail, or more general ones in the event of a conflict. Article 53 of the Vienna Convention on the Law of Treaties does void and terminate an existing treaty if a new peremptory norm or general international law emerges. A peremptory norm is one that is considered superior to other rules of international law. The formal definition of a peremptory norm exists in Article 64 of the Vienna Convention on the Law of Treaties, which defines it as a norm accepted and recognized by the international community of states as a whole. A reservation is indicative of the consensual nature of international law. A reservation is where a state seeks to exclude the application to it of certain provisions of a treaty which it is otherwise willing to accept. Article 2, subsection 1 of the Vienna Convention Law of Treaties states that a unilateral statement made by a state when signing, ratifying, accepting, approving, or acceding to a treaty, whereby it purports to exclude or modify the legal effect of certain provisions of the treaty in their application to that state. The traditional approach was that a state could only insert a reservation if all other states to the party consented. This would make meaningful lawmaking virtually impossible. The ICJ in 1951 was requested to provide an advisory opinion on the matter of validity of reservations. In its advisory opinion, the court adopted a more flexible and realistic approach. Article 19 of the VCLT states that a party may, when signing, ratifying, accepting, approving or acceding to a treaty, formulate a resolution unless the reservation is prohibited by a treaty. The treaty provides that only specified reservations which do not include the reservation in question may be made, or in cases not falling under subparagraphs A and B, the reservations is incompatible with the object and purpose of the treaty. A reservation that is not in breach of the above requirements may be accepted. Now we should take a look at what is customary law. Professor Braley, in his 1963 classic The Law of Nations, defined custom as something more than a mere habit or usage. It is a usage felt by those who follow it to be an obligatory one. Customary law is how states behave because they feel they are legally obliged to do so. The example of protection of envoys and diplomats will help. It is one of the oldest rules in customary international law that states both send and receive envoys under the notion that they will not be harmed. Over time, this practice was perceived as not just what states did, but as how they were obliged to behave. Article 38, subsection 1, paragraph B, UN Charter stipulates two essential elements of customary law: a general practice, and that practice is accepted as law. This is the mental element, which is known as opinio juris. In reality, the two elements, state practice and opinio juris, are closely intertwined. This was summarized by Judge Tanaka in his dissenting opinion in North Sea Continental Shelf Case 1969, where he stated the time factor, namely the duration of custom, is relative, the same with state practice. Not only must each factor generating a customary law be appraised according to the occasion and circumstances, but the formation as a whole must be considered as an organic and dynamic process. What is needed for a rule of customary law to exist is in paragraph 74 of the majority judgment of the North Sea Continental Shelf case. It noted an indispensable requirement would be that within the period in question, state practice should have been both extensive and virtually uniform in the sense of the provision invoked. Practice is established by those states whose interests are most affected by uniformity of practice. The time period is not a key factor. The relationship between practice and obligation must be considered. In the very famous Nicaragua case, Military and Paramilitary Activities in and Against Nicaragua, it noted that in order to reduce the existence of customary rules, the court deems it sufficient that the conduct of states should in general be consistent with such rules, and that instances of state conduct inconsistent with the given rule should generally be treated as breaches of that rule and not indications of the recognition of a new rule. Now we should take a look at resolutions in customary law. An issue that often becomes the cause of confusion is the status of the resolutions of the General Assembly of the United Nations. The most important thing to bear in mind is that resolutions are not formally legally binding. The instruments adopted by the General Assembly are known as declarations or resolutions, which do not suggest legally binding content. Another source of international law are general principles. Professor Crawford provides a useful description of this source of international law. A rigid categorization of sources is inappropriate. Examples of this type of general principle of international law are the principles of consent, reciprocity, equality of states, finality of awards and settlements, the legal validity of agreements, good faith, domestic jurisdiction, and the freedom of the seas. General principles describe a number of different concepts. Judge Ammon in the North Sea Continental Shelf case described these principles as nothing other than the norms common to the different legislations of the world transposed to the international legal system. Another source of international law are judicial decisions. Judicial decisions are not primary sources of law but are subsidiary means for the court to determine the law on a matter. The decisions of the numerous international courts and tribunals and the supreme domestic courts can be used by the ICJ to develop the content of international law. They are indicative as to what the law on a matter may be. In human rights law, this is important as the number of international regional bodies dealing with human rights issues has increased extensively. The ICJ is also competent to deliver advisory opinion, but is not legally binding. The principles ex equo et bono and equity, Latin for according to the right and good, or from equity and conscience, must be considered. Article 38, paragraph 2 of the Statute of the ICJ states that paragraph 1 of that article shall not prejudice the power of the court to decide a case ex equo et bono if the parties agree thereto. To date, this provision has not been applied, but determines that the court may decide a dispute according to the justice of the case, providing the parties consent to this approach. This allows the court to go beyond the limits of the existing law. Now we should take a look at two terms, jus cogens and erga omnes. This term describes certain normatively superior rules of international law, rules that are so important that all states have an interest in their breach by others, and further, even if some are breaching it, the rule still continues to apply to others. Jus cogens are rules of overriding obligation. They cannot be limited or suspended and apply to all, so long as the international community of states as a whole does not develop a new rule. Article 53 of the VCLT refers to them if rules are just cogens, they can void any act that is not in accordance with them. These rules express fundamental values. There are other rules that are related to just cogens but are legally distinct, as those are the rules that are certain international legal norms in whose violation all states have a legal interest. These are the obligations erga omnes. These were first identified by ICJ in its dictum in the Barcelona traction case Belgium versus Spain. In paragraphs 33 to 34, the court stated, an essential distinction should be drawn between the obligations of a state towards the international community as a whole and those arising vis-a-vis another state. By their very nature, the former are the concern of all states. All states can be held to have a legal interest in their protection, their obligations erga omnes. This means that certain human rights are considered to be superior than other human rights norms and other norms of international law. Now we should take a look at the relationship between international law, human rights, and domestic law. There are two approaches that should be discussed, monism and dualism. The traditional way in which this is considered is to draw a contrast between approaches which are labeled monist and dualist. A monist approach considers there is one legal order of which international law is a part. A dualist approach considers two separate legal systems, domestic law that applies internally and international law that binds the state in its relations with other states but has little role automatically in the internal legal system. Thus, customary international law may automatically be considered part of the domestic legal order, but a treaty may only have effect internally if there is a specific legislative measure giving effect to it. The essence of monism is that international law and domestic law are inherently part of one coherent system. The Netherlands is often considered a classic monist state. The dualist theory holds that international law and domestic law exist in different spheres. There is no clash between them, each is supreme within its own area. The United Kingdom is a classic dualist state. A statement on the approach adopted can be seen in Lord Hoffman's judgment in R versus Lyons 2003. He stated, it is firmly established that international treaties do not form part of English law and that English courts have no jurisdiction to interpret or apply them.